My name is Paul. I am one of the instructors here at Penn Foster High School, primarily in the social studies courses. If you ever want to get in contact with myself, our other instructors, our teaching assistants, you can certainly give us a call at 1-888-427-1000. Option 5 will get you to the education department, myself, and again, the instructors and TAs. You can also use the help and support page on your website to send us an email. You'll just be able to do a quick search of a question, be able to see a Ask a Question tab, and then be able to compose an email that will come right into our education department. And within usually 24 hours, we are typically able to answer emails and be able to get back to you on any questions that you all have. So by all means, we're certainly here to help you out. So by all means, get in contact with us. You can also make sure that you use the live help and the webinars that are available in your message center. Myself, the other instructors, we all provide live webinars and live office help throughout the week and throughout the month. So early on here in June, by all means, check out those webinar schedules, sign up for webinars, attend live help, ask questions there. And we are, again, very willing and very able to help you out with any questions you all have. So make sure that you do contact us when you have questions. One of the big things I like to let students know about is just in terms of helpful hints. The reading assignments are really key for many of your courses within the program. The courses that have textbooks, you'll want to use both the reading assignments and the textbook. But primarily, in those reading assignments, you're going to see a wealth of knowledge about pertaining to your objectives. I always recommend to actually take notes based on the objectives, as well as using those practice exercises within the courses. They can be short answers, they can sometimes be multiple choice, matching, flashcards, anything like that are all there to help you and are there to make sure that you're making sure that you're understanding the material and preparing for the exams. So when you have done well on those practice exercises, you're more likely to be successful with those exams because they're all connected. The objectives help us write the material, they help us create the practice exercises, and they help us create the exam questions. So the better you are understanding the objectives, understanding the exams, understanding and completing the practice exercises, the more likely you are to completing and doing well in your exams. You will receive a recording of this webinar tomorrow, so you don't have to worry too much about taking notes feverishly or worrying about missing anything. You will receive this recording, like I said, tomorrow afternoon in an email, just like your registration email. So in general, our webinar today will be covering the next section of your Constitution lesson, which will go over the Bill of Rights and other important constitutional amendments. We'll talk about how the Constitution is able to be amended. We've had 16 amendments to the U.S. Constitution since the Bill of Rights, the first 10 amendments, and each one of those times required obviously creating an amendment. So we'll kind of talk briefly about that process. And then finally, we'll look at how the Constitution has been interpreted and how that process is done. So in terms of the Bill of Rights, it's important to know that the Bill of Rights, as you may know, came up right after the Constitution was originally ratified by the 13 states in the new United States. But the Bill of Rights came up right afterwards because the group who was actually opposed to the Constitution, those who believed the Constitution had too much power in the federal government, they were called the Anti-Federalists. They believed that power needed to be centralized, or should not be centralized, should only be with the people and only at the state and local level. So they wanted to make sure that the federal government had a list of rights that that were needing to be protected, because the Anti-Federalists believed that a large federal government would infringe on people's rights. So they wanted to make sure that there were 10 basic rights written into the U.S. Constitution as new amendments to make sure that those rights are protected. And we'll talk through all of these amendments. The starting off with the First Amendment. The First Amendment does protect. These are some of the sort of the natural rights, the basic rights, and it includes the right to religion. And there are two parts to this. The first part is called the Establishment Clause, that the United States government cannot create its own religion or favor one religion over another. It also requires that the government is not allowed to stop anyone from freely exercising, worshiping, or taking part in their own religion. The federal government and eventually all governments are not allowed to do either one of these things. They're not allowed to establish a religion or favor a religion, and they're also not able to stop anyone from practicing their religion. Our founders saw this happening within England, that England had favored a religion. They favored the Church of England, and they weren't allowing groups like the Puritans, the Quakers. They weren't allowing these religious groups, from practicing their religion. So our founders really wanted to make sure that this was a basic right that was protected by the Constitution. The First Amendment also guarantees the right to free speech, that as long as you are not causing harm on someone else, you are able to say whatever you want. You're able to protest. You're able to write articles. You're able to write signs. You're able to do all these types of things. You're able to make phone calls. You're able to do so much in protest of anything, or in celebration of whatever you want to, and the federal government's not allowed to stop you. The First Amendment also guarantees the right of a free press. So newspapers, magazines. Now we know magazines. We know internet news. They are able to freely write their stories, ask questions. They're able to do all sorts of things guaranteed by that First Amendment. Americans are also able to peacefully assemble. So anytime you see a protest, we saw a lot of protests at the beginning of the new Trump administration. Those were all guaranteed by the First Amendment. So again, as long as they are peaceful, as long as they are following specific rules that a city or a state might have in terms of having a permit, being able to march in different areas, or in specific areas, I should say, people are allowed to protest. They're able to assemble. And finally, they're able to petition. So there may be a lot of petitions online that say, we want this to happen, we want President Trump to do this, we want Democrats to do this, we want certain government officials to do these things. These are all petitions. These are all citizens wanting to collect voters, collect people on a specific issue. And again, these are basic rights. These are rights within the First Amendment that the Constitution has. That groups like the Anti-Federalists, who wanted to protect basic rights, wanted to make sure that the government could not infringe on these rights. The Second Amendment to the Constitution guarantees the right to bear arms. Now, this is perhaps, along with parts of the First Amendment, but the Second Amendment has a lot of critique and a lot of people for and against this right as well, in which many people argue that the right to bear arms is really about having an organized militia, having an organized military. And now that we already have that, what does the right to bear arms mean? Today, it's our Supreme Court in recent cases have now said that the right to bear arms really goes to the idea that people are freely able to individually have guns and have arms for themselves. But again, the both of these amendments have a lot of controversies to them, and a lot of questions about what they mean, even in today's society. Does that right to bear arms, is that basic or that permanent right really still supposed to be permanent? Do we really need as much of a right to bear arms? Equally, do we still need a full right to free speech? Are there limits that we should have based on what people say, based on what people do in terms of actions? A lot of these types of debates are going on within the country. And that brings us to our first poll question. Sorry, the system is being a little slow for me. Okay, here's the poll question. So who argued for the creation of the Bill of Rights? Was it the Federalists? Was it the Anti-Federalists? Or was it the Democrats? What kind of political organization called for the creation of the Bill of Rights? Okay, thank you so much. And absolutely correct that it was the Anti-Federalists, those who believed that believed in protecting people's rights. The Federalists were much more interested in having a large federal government. They actually argued during the course of the ratification process that the U.S. Constitution was automatically going to protect many of these rights that are in the Bill of Rights. But the Anti-Federalists, even though they lost the ratification, even though the Constitution was ratified, the Anti-Federalists were able to get this kind of concession from the Federalists, from the ruling party, that these basic Bill of Rights would be voted on, would be approved by within the new Constitution. So continuing on with the Bill of Rights, the next amendment is called the Third Amendment. Essentially talks about the fact that soldiers, that military soldiers, are not allowed to stay in private homes. This was an issue that was very important at the time of the ratification and the time of the American Revolution. One of the big issues that caused revolution, that caused more American colonists to want to be free from Great Britain, was the issue that in many parts of the colonies, British soldiers were allowed and actually encouraged to go into people's homes and stay there, and to live there essentially, and to take away their rights to privacy. And this amendment has really been interpreted over the years as being less about specifically soldiers not being able to stay in people's homes, but far more about government intrusion, and that our government is not allowed to just walk into our homes and assume responsibilities, assume ownership of our homes. There are certain rights that we have to have in order for our government to either need to come into our home, be able to search our home. We'll cover that in a couple minutes. But it's essentially, this amendment really safeguards, protects our right from government intrusion. Our Fourth Amendment goes specifically, and this again kind of goes into government intrusion, but the right that police must have a warrant to search and then to seize any property. And again, this really goes to the idea of privacy, protection of people's basic rights and people's basic to stay away from government intrusion, that the government must have reasons to get a warrant. They must have a reason to request either looking in your home, looking in your vehicle, looking on your being able to search you at either police stops or at the airports. There has to be a reasonable there has to be a reason for intrusion. There has to be a reason for searches and seizures. Now, so the Fifth Amendment gets into far more about rights of people who are accused of crimes. And this starts off with the fact that a grand jury must be created to investigate a capital crime. A grand jury is a group of people's peers. Ordinary Americans are part of grand juries in which they then look at the evidence that's collected by the police, that they then make the decision whether or not a person can then be arrested for that crime. So the grand jury, a jury of our peers, are actually looking at a case to say whether or not there's enough evidence to bring about a case. The Fifth Amendment also says that there cannot be double jeopardy. Double jeopardy means that you cannot be tried for the same crime twice. That once you are found innocent of a crime, you are innocent of that crime no matter what. That even if more evidence is found, that a person cannot be tried for that same crime. There's also the idea that people say that I'm taking the Fifth Amendment. When people say taking the Fifth, that means that you are able to not answer any questions, so you are not incriminating yourself. That doesn't necessarily mean that you did anything wrong or anything illegal, but it does mean that because you are afraid of what questions might be asked, or you're afraid of how you're going to answer it, people are able to take the Fifth, are able to say that I'm not going to testify against myself or answer questions about myself. That is another guarantee within the Fifth Amendment. It also guarantees fair treatment. So the courts cannot treat anyone differently. The police cannot treat anyone differently based on any reason, based on race, based on wealth, based on religion. All these things, the courts must be blind. Justice must be blind to anyone's conditions before they are tried or before they are brought in for questioning. The Fifth Amendment also speaks to eminent domain, which means that if a government has reason to seize property or take property, they are able to give the homeowners something for it, usually an amount of money for it, but it is within the right of the federal government or any government to be able to take property, but they do need to give reason for it, and they do need to give proper compensation. Continuing on with the amendments, the Sixth Amendment, kind of going along again with the rights of accused, requires due process. That there has to be a trial, there has to be a show of evidence. There requires to be a speedy trial. The accused must be informed of their charges, so that you're not able to just be arrested, go in front of a judge, and they say, well, you're guilty based on the evidence. People have to be able to be informed of the charges. They also have to be represented by attorney, and they also have to they have the right to be declared innocent. And once they're found guilty or say that they're guilty, be declared guilty, the judge is then sentences the person. So it's not based on what the prosecution wants, it's not based on the jury, it's based on the judge. The Seventh Amendment requires jury of your peers to be part of a trial, so to be convicted, to be found innocent or guilty by the jury of your peers. The Eighth Amendment makes it against the law to have any cruel and unusual punishment. So the crime, the punishment must fit the crime essentially. It also makes it illegal for excessive bail. So if there's someone who's charged with a crime, the bail cannot be so high that that person wouldn't be able to would be unable to make bail. The Ninth Amendment sets up enumerated powers, which means that it set up the fact that the federal government and the state governments, and this goes also along with the 10th Amendment, that the that sets up the abilities that the state has, the powers that the state has, as well as the federal government. And that leads us to our next poll question. Before a trial begins, what doesn't a defendant have the right to? Representation of a lawyer, the sentencing by a judge, or being informed of charges. So before the trial begins, what doesn't a defendant have the right to? Give 5 more seconds. Okay, thank you so much. So at the end of or before the trial, a defendant actually does not have the right yet to be sentenced by a judge. So number 2 is the correct one. They do get representation of a lawyer before a trial, and they are informed of their charges before the trial. So eventually there will be the sentencing by the judge, but not before the trial. So now that we've gone over the first 10 amendments, the Bill of Rights of the Constitution, let's talk a little bit about other significant amendments. So the next kind of big ones are what's called the Civil War Amendments. And these are called Civil War Amendments because they come shortly after the Civil War ends. So in 1865, the 13th Amendment is ratified by our Congress, which freed all slaves. So any slave that was back in a state back in the Union was now a freed slave, was now a free person. Back in 1863, when the Emancipation Proclamation was signed by President Lincoln, that only affected those who were in the Confederacy. And now this amendment really freed them now once the Confederate States were now back in the Union. Just a few years later, the 14th Amendment guaranteed citizenship to all people within the United States, including the newly freed slaves. And the 15th Amendment, passed 2 years later, gave all men the right to vote, meaning all, including African American slaves, former slaves. In 1919, the U.S. Congress passed really the first and only constitutional amendment that limited rights, and that was the 18th Amendment, which began prohibition. When alcohol was not allowed in the country. This amendment went so well that in 1933, just 14 years later, the 21st Amendment ended the prohibition, so allowing alcohol back in the United States. There had been, just in those 14 years, a vast criminal empire was created across the country, in which people were bringing alcohol, or making alcohol themselves, or bringing alcohol from other countries illegally into the United States. So really, the only amendment that limited rights in the United States caused massive crime, and again ended just 14 years later. In 1920, the 19th Amendment was passed, giving women the right to vote. And then the 26th Amendment in 1971 gave 18-year-olds the right to vote. So again, we see this expansion of voting rights, the expansion of rights in general to the American people. And that leads us to our final poll question, which is, what's the only amendment that limited people's rights in the United States to the Constitution? Was it the 14th Amendment, the 18th Amendment, or the 26th Amendment? Okay, give you guys about 5 more seconds. 3, 2, 1. Okay, thank you. So it is actually the 18th Amendment, that the amendment that started prohibition as the only amendment that that limited the rights of the American people. The 14th Amendment guaranteed citizenship to former slaves, and then the 26th Amendment gave 18-year-olds, everyone the age of 18 and older, the right to vote. So next we'll talk about the amendments to amending the Constitution. So we've seen 26 amendments have been passed by the United States since the Constitution was ratified. In order to do that, it has a very high bar in terms of popularity and acceptance by the American people. So in order for an amendment to just be proposed, for it to be able to go in front of the American people, either 2/3 of Congress or 2/3 of states in a national convention have to agree to propose the amendment. So again, this is a very high mark. So 2/3 or 66% of Congress or of the states need to accept this amendment. In order to ratify the Constitution, the new constitutional amendment, it requires 3/4 or 75% of either state legislatures or a convention of states to accept the new amendment as well. So it can't just be based on politics. It can't be a Republican amendment or a Democratic amendment. It has to be a large number of people in both political parties agreeing to an amendment in order for it to be passed. The study unit, the reading assignments within the Constitution, also kind of goes over some really big ideas that the Constitution created, and it's interesting that the founders really had these ideas in mind as they were creating the Constitution. The first big idea was the separation of powers. Our founders really believed in what's called the rule of the many. That as long as many people were involved in government, either as elected officials or just as voters, as long as many people were involved in the system, that was a good thing. That was a positive. And they really went back to the old quote of power corrupts and absolute power corrupts absolutely. That some power by some individuals, thinking about a president might be corrupt, a member of Congress might be corrupt, a governor might be corrupt, and we've had them in our history. These people may be corrupt, but they can only be so corrupt. They can only have so much power. If we start giving too much power to certain individuals, certain positions, then that corruption becomes that much more powerful. Our founders also believed in a check and balance system, that it wanted to limit power of each branch, and they really wanted a healthy distrust by our government officials. They wanted, for instance, the president to distrust Congress. They wanted the Congress to distrust the president. They really wanted our court system to distrust really both branches of government. So the president has a power to check Congress. The president is able to say, well, the laws you're passing are not good ones. So the president has the power to veto a law, reject a law. The president can look at the power of the courts, and say, you know what, you guys aren't really doing a good job, so I'm going to nominate better judges. I'm going to make sure that better people are in your positions. Congress can also check the court's powers by actually impeaching them. They're able to impeach, remove from office both the court judges as well as presidents. They're able to impeach. They're able to remove and then convict government officials from office. Congress is also able to check the president's power. They have to approve any new law the president wants to pass. So a lot of different ways that our founders created that check and balance system to make sure that no one branch has too much power, that they're always able to check the amount that they can do. Another big idea is called popular sovereignty. And the study unit or the reading assignments define that as the people in the state can determine the laws within the state. So according to our founders, voting is an essential right in a representative democracy. That as long as that people have to be engaged, people have to be voting, people have to know about the issues in order for representative democracy to work. The last big idea is called federalism, that power is shared between both the central and state governments. It's essentially another part of the check and balance system. Now, since the Civil War, our federal government has gained more power, has expanded in terms of power. At the end of the Civil War, the federal government had to expand its power over southern states in order to make sure and to ensure rights of African Americans, former slaves. Our federal government had to expand during war times, during World War I, during World War II, during the Great Depression, to ensure tranquility and to ensure peace and to ensure prosperity for many more Americans. So again, much more power. More recently, the federal government had to expand powers in order to expand health care by both President Obama and by President Bush before him. The federal government has had to expand in different aspects, in different parts, to meet needs, but there's still an essential requirement that the states still had shared power. That the state of Pennsylvania, the state of North Carolina, the state of Texas still have a lot of autonomy in terms of how they will enforce federal law or how to expand their own laws, what services they are going to provide, what rights they want to allow their citizens to have. Now, there are certainly challenges to all of these big ideas, and it's been going on since America's founding, that within separation of powers, there's still much more concentrated power over the years into the executive branch. That in wartime, the presidency has a lot of authority, has far more authority than any other time, in any other instance. In terms of the check and balance system, sometimes the powers are not able to be enforced. There was a President Andrew Jackson wanted to remove Native Americans from a settlement in Georgia. The Supreme Court told him, no, you are not allowed, based on the constitutional rights of these Native Americans, you're not able to remove these Native Americans. President Jackson said, well, I'm still going to do it anyways, and actually rounded up a large group of Native Americans and forced their migration west in order to have more settlements for other people. So sometimes it's not, the checks that are created by our federal government is not able to be enforced. Another example, when George W. Bush would have what's called signing documents or signing speeches. Sometimes he would actually sign a bill, and then when he gave his signing statement proclaiming that he was going to follow that law, he actually would eventually say, no, I'm actually not going to enforce this law. This is what I'm going to do instead. Instead of what Congress wanted me to do, I'm going to do this. There's been a large amount of laws across the states that have limited voting rights. It's created systems in which people have to get documentation or get IDs that not all people can get. Not all members or all residents in a state are able to get the proper identification to be able to go and vote. This has become a major issue in the last 10 years or so, that people who want to vote, who should have the right to vote, are not able to get the documentation or get the proper ID system to be able to vote. And as I mentioned before, the last challenge to federalism, that the federal government has gained a lot of authority over the years, based on needs that they want to be able to achieve. Lastly, I'll talk interpretation of the Constitution. Next week, when I go over the rights or the government section of the judiciary branch in our federal government, which is part of Part 3. Or part of the third lesson, we'll talk a lot more about the interpretation of the Constitution by the Justice Department or by the federal courts. But there have been just a few cases in federal courts that have really affected the interpretation, really affected the rights within the Bill of Rights. The first one was called Marbury versus Madison. And it all set up with the Judiciary Act of 1789, in which the federal courts, the federal judges, or I'm sorry, the Congress and the presidency wanted to set up this law that said that any government official that Congress would be able to create, or the executive branch, the presidency, would be able to create any government official or government position that they wanted. And our our Supreme Court actually ruled that unconstitutional, creating judicial review. That the federal court system believed that in order to interpret the Constitution, which is essentially what the Supreme Court and the court system is supposed to do, they need to be able to rule laws unconstitutional and force the Congress and the presidency to actually rewrite the law or change the law in order for it to meet the Constitution. Another famous court case was for Brown versus the Board of Education, in which the Supreme Court in 1954 declared that the idea of separate but equal conditions for white and African Americans was unconstitutional. That it created this ability of equal opportunity within our public school system, and eventually it ended segregation in all parts of the South and all parts of the rest of the country. Legal segregation was ended, and began a significant steps in the civil rights movements. That instead of simply protesting laws, our civil rights movement leaders like Martin Luther King Jr. was able to look at this Brown versus the Board of Education Supreme Court case and start challenging other aspects of segregation and segregation laws. And like I said, eventually this same idea of separate does not mean equal would result in segregation ending across the country. This last case, the Heart of Atlanta Hotel versus the U.S., was another step towards the ending of segregation. That the interstate commerce, as part of the United States Constitution, was harmed due to discrimination. That this hotel wanted to be able to keep certain races, primarily African Americans, out of their hotel. And the U.S. government and the Supreme Court agreed that this was a form of segregation that was harming the U.S., and that local laws could not allow for white-only establishments. And so as the court cases and as our federal court system and our federal government, our Congress, our presidency, have been able to look at the Constitution as a changeable document, as an interpretive document, that the Constitution was really created to be able to bend to situations and be able to bend to what was necessary within the United States and within society in general. That is the end of my presentation. Does anyone have any questions about the lesson?